Uganda and Kenya, especially during the COVID-19 pandemic. I think that this report is important for anyone interested in learning about surveillance, the environment in both Uganda and Kenya. But before I provide spoilers, I would like to invite the 3 organizational heads that have worked on this report to give some opening remarks. You each have 3 minutes, and we will start with Mugambi from Article 19, then Grace from the Kenya ICT Action Network, and lastly, Nima from Pollicy. So over to you, Mugambi first.
Hi, Jackie. I can see Mugambi has joined us, so perhaps Grace or Nima can kick off.
Okay, so I think Nima, we go first with you.
Sure. Hi, everyone, and thank you so much for joining us on this conversation. I am very proud of the work that we've put together, and we're very happy to share it with you on this webinar and more broadly. I think this is a good step in making sure that the voices of the people that we have spoken to come to light, especially I find when we're talking about issues of surveillance and data protection, I do find that they can be quite jargony and quite difficult topics to digest. So I'm really excited that we have been able to take some of that and make it into a video and make it accessible to more people so that we can bring more people into this discourse about what our data protection looks like, why it's important to be having these conversations, and what do we want this to look like moving forward? What kind of checks do we need in place to make sure that people at the margins who are most likely to be impacted by the failure or the success of this law come to the forefront. So thanks so much for joining us. I'm really looking forward to the conversation. Over to you.
Thanks, Nima. Grace, maybe we can go with you next. If Grace is not available, Mugambi, are you there?
Hi, Jackie. I'll handle the opening remarks on behalf of Article 19, if you'll permit me. Good morning, everyone.
Feel free. Could you please introduce yourself?
Yes, I will. Morning, everybody. My name is Sigi Waigumo Mwanzia. I am a digital program officer at Article 19 Eastern Africa. My apologies, Mugambi Kiai is joining us and is having several teething issues, but will be joining us shortly. So I guess to kickstart off and to build up on what Nima has already mentioned, I just want to draw everybody's attention to the catchy but more telling title of this joint partnership between the 3 organizations, the Unseen Eyes, Unheard Stories that we've been seeing circulating, hopefully, on social media platforms. Now, when the project partners first started collecting data in Kenya and Uganda, we observed 2 things. One is that individuals are afraid to speak out about their lived experiences as subjects of pandemic surveillance measures in both countries. And here we are putting stigma concerns aside. Secondly, we also observed what we like to call an information faucet, where the public's right to know was not proactively promoted, given failures by both state and non-state actors to disclose crucial information and to disclose and publish documents related to their pandemic surveillance measures and practices, including about public-private partnerships. Now, I just want to pause for a second and acknowledge the fact that a public health crisis, such as the ongoing coronavirus pandemic, may necessitate certain track and trace measures and powers for public health purposes. However, we must always recall that international human rights law specifies that, 1, these actions be temporary, and that these actions must satisfy the 3-part test of legality, legitimacy, necessity, and proportionality. So what are some of the observations that we will deal with as the discussion proceeds? We observed that the measures which were rolled out in both countries have deprioritized human rights protections. We've documented instances where state and private actors have used location data in a manner which scorned digital anonymity, consequently threatening various rights, including the right to privacy, the right to freedom of expression, amongst others. We also observed incidents where actors, both state and non-state, collected and processed personal data without proper regard for data protection safeguards in the data protection laws that Kenya and Uganda both have. We also documented situations where access to information requests about government's responses to the pandemic were either ignored and are still ignored, all of this under the guise of tackling and addressing the pandemic. So I just want to, in closing, I just want to wish everybody a very enriching session during the webinar, and thank you all for your kind attention. Over to you, Jackie.
Okay, so Mugambi, I guess Mugambi is not around. Maybe we can have Grace.
Okay, good morning, everyone. My name is Grace Gidaiga. I convene the Kenya ICT Action Network, or KICTANet, which for those of you who may not know, acts as a multi-stakeholder platform and brings together institutions and individuals interested in ICT policy and regulation. So as a network, we aim to catalyze ICTs for reform, and we have continued to do that. Part of our membership comprises representatives from government, from civil society, from academia, from philanthropic organizations, and even the technical community. In terms of our work, we conduct researches in areas of ICTs or internet governance. And so we've produced reports, we've produced policy briefs, and we also make submissions on key ICT policy concerns to relevant authorities or the regulator and so on. So our interest in this work and in this collaboration between us, Article 19 and Pollicy, is that it was informed by our concerns that yes, a pandemic had happened on us. Nobody had expected anything of this sort. But then the tools that were put in place to follow or to capture the data of those who are affected or those who are suspected to have been affected were actually questionable. So there was clearly surveillance using phone numbers as those who are, those who, for example, arrived into the country and were told to self-quarantine, were told to be home for 2 weeks. And if they left, people got calls and they were told, go back home. And in as much as this was deemed as a way of curbing the pandemic, I think, clearly it's, there are levels of intrusion into citizens' privacy. And as this was done, there wasn't a framework to guide the process. So, there were also, like if you tested positive or you had been with somebody who tested positive, people would receive calls from numbers that, ordinary numbers that they did not expect. So there wasn't like a number, the way Safaricom tells you, we only call you from this number. And so you got random, you got random calls from different people. And sometimes Kenyans thought the calls were from committee. So they didn't even take that seriously. We were also concerned that the process, succeeded in stigmatizing those affected. And even, Kenyans started giving fake numbers, fake phone numbers, or giving other people's numbers instead of their correct phone numbers. And, even as now we move into the vaccine, if you go to any of those vaccination centers, there's usually like, they have a book. and they have all that data. So, when you come like you're number 20, you can actually see the information from all other people who have actually taken the vaccine, and that book is there. So there are still questions to be raised about the safety mechanism of people's data, what safeguards have been put in place. And I think these are questions that we must continue raising until there's a mechanism for that. So as KICTANet, we are asking the government to engage the public and provide accurate, timely, and complete information about the nature and extent of COVID-19 surveillance measures in place. In addition, we would want proper oversight and sufficient safeguards that are consistent with data protection principles, which must be implemented given the sensitivity of health data. Health data is not just any other data. And so, we are so glad that you have joined us for this launch. And just like Sigi has said, and I'm sure Nima, I'm not sure whether Nima, I joined a bit late, I was having challenges. But we really look forward to a stimulating engagement in this session, and that we will even get more points to add into the report. So thank you.
Thank you so much. Thank you, Grace. I see that Dr. Wakabi from CIPESA, who are the key funders, is on the Zoom call. Dr. Wakabi, if you have 2 minutes to spare, could you please say something from the funders' perspective?
Sorry, hi, Wakabi here. Good morning, everyone.
Morning.
I'm very glad to witness the unveiling of the research findings. I am not here as a representative of CIPESA, but as an interested party in this field of work. So I'm all ears, all eyes to see how the research panned out, because obviously this is a live issue in our region, which very much affects very many digital rights and other rights. So we look forward to seeing the research results and how they can be used further, such as in advocacy work. Thank you very much.
Thank you so much, and thanks all organizational heads and the CIPESA team as well. Now I'd like to invite everyone for the video screening. So these videos are from both Kenya and Uganda, highlighting the unseen eyes and unheard stories of surveillance that many of us have been subjected to, knowingly or unknowingly. And before the videos start, maybe if you have any comments about these clips, please feel free to utilize the chat option. So here we go. Enjoy the viewing.
Ni saa 6 ya usiku, nikapata namba ya kigeni. Kushika simu, wakanambia sisi ni watu wa COVID. Tumekuja kuchukua sample. Nikauliza kuchukua sample wapi saa hii tena usiku? Na mumejuaje kwangu? Another friend of mine alipata COVID. So vile alienda Bagathi, alipeana majina ya wale watu wako close to her, around 12 to 12:30. Hiyo ilikuwa usiku. Nikapata namba inanipigia simu. Sikujua ni nani. Vile nilishika hiyo namba, mtu akanambia sisi ni watu wa COVID na tuko hapa kwako nje. Nikamuuliza hao, nani amekuonyesha kwangu? Akasema wewe usijali nani amenionyesha kwangu. Sisi ni watu wa COVID na tunakuja kuchukua samples. Nikafungua mlango, nikaenda kwa balcony. Nikapata nje watu wamejaa hapo chini. Ni kama kuna commotion. Kuna ambulances, kuna hizi basi kubwa za NYS na kuna gari za polisi hapo.
The emergence of the COVID-19 pandemic caught most of the world's government off guard. Addressing the pandemic has required effective responses by the government, private sectors, and the international community in general, including tracking the infection rates and preventing the spread of the disease. While digital technologies can assist in the delivery of such responses, surveillance technologies raise significant risk to human rights, including the right to privacy, data protection, freedom of expression, and access to information. Kenya confirmed its first coronavirus case on 13th March the year 2020, and just like the rest of the world, Kenya turned to technology to help curb the virus. The surveillance measures and practices adopted to contain the coronavirus pandemic, including coronavirus applications, did not comply with the three-part test under the international law and national laws guaranteeing the right to privacy, data protection, freedom of expression, and access to information. Several contact tracing apps were created, amongst them being Jitenge, which means self-isolate in Swahili, which was developed by Kenya and jointly developed with the Ministry of Health. This application was meant to assist Kenya health officials to trace contacts.
The aim of these contact tracing applications, as described by the developers, was that they will provide an easy mechanism to trace individuals who perhaps have tested positive or people who've interacted with people who've tested positive. So there are different kinds of technology used, and the most common was Bluetooth technology. And that apps were that they created an app that if you come across or interact with somebody who's tested positive, you'll get a message say, hey, by the way, you interacted with somebody who tested positive, you also need to get tested. The apps have also been used to monitor people who've either traveled or have tested positive in some countries to ensure that somebody is self-isolating. For example, somebody is quarantined and they're not going against those quarantine guidelines because the app, using the mobile phone technology, if you go outside a certain area, then the app notifies the authority. If you have symptoms that escalate, you'll put that information in that app, and that will allow for immediate action by the authorities.
Contact
Just a moment as I bring in the Ugandan section of the video for the rest to see.
Awesome. Thank you, David. As David pulls up the Ugandan video again, remember that this webinar is being recorded and will be published publicly with the 3 different organizational platforms, as well as you can join the conversations on Twitter, YouTube, and Facebook as well. Okay, so the Ugandan version is starting. David, go ahead.
Twali tuli awo nga twakamala okuziika nga tukomewe waka because twazika mchalo bayitayo mayuge nga DMO, that is district medical officer wa Jinja district, najja n'abasawo ne double cabin ne batugamba batwala mu quarantine. It was a tough time because nga tulaba batwala mu bintu byetu tategeera. First and foremost, echatamama tuchimanyi yafa pneumonia. She died of pneumonia that was on acute stage, ngali manageable. So kati batugamba atafudde COVID. Tugenda okumaliriza nga betulimu biri so confusing.
This is Apostle Julius. His mother died of acute pneumonia, which was misdiagnosed as COVID-19, a mistake that would soon come back to haunt him.
Batukwata awo tukuba ne police yajja batutwala nga bayeekera ne batwala sample yasooka bwe bagitwala nedda nga tuli negative. After like 7 days they took another sample nayo nebula eyo teyadda nakudda actually batugamba nti yebuze sample zabula.
The Ministry of Health would like to inform the general public that Uganda has confirmed her first case of coronavirus disease, COVID-19.
The Uganda government immediately enacted stringent measures to curb the spread of the virus, from shutting down all of the country's border points to enacting a 24-hour curfew. And by amending the Public Health Act, Government and Ministry of Health expanded the search powers of health workers, allowing them to make arbitrary visits to any premises suspected of having COVID-19 patients.
Government looks at the majority, protecting the bigger picture, the majority, the many, so that we have some lives tomorrow. And in that, some of the measures may, to some extent, hinder or infringe on your freedoms.
At the beginning, they would come and do tests every 2 weeks, the ministry. Like the very first time, we had a few people who were positive, and that time it was the time the stigma was very high. They would collect you from your home. Well, like the whole village now doesn't want to talk to me because they saw me being taken in an ambulance.
State and private actors have collected, processed, and shared personal data, including sensitive health information, which is in breach of the Data Privacy Protection Act of 2019.
Yes, information was collected, even when it was necessary. Challenge is there are no regulations to regulate the use of the data and collection of the data.
We don't have enough data protection for the end user. This is partly because the health workers involved in this COVID intervention do not have enough awareness on data protection. So in this situation, health workers have been moving around trying to trace COVID contacts, but also they've been collecting information which has been personal and intrusive in nature.
Take the example of Apostle Julius, whose unconscious mother had her COVID swab taken without anyone's consent.
Okay, thank you so much for those short videos. And the videos are longer than that, but we just showed a 3-minute clip for each. So if you want to watch the full videos, please feel free to go to the different organizational website. And I think that these websites will be placed in the chat for everyone to find them and follow as well, but also go to see the full length of these videos. So now we move on to the big day, or the main event, which is the launch of the report titled Surveillance, Data Protection and Freedom of Expression in Kenya and Uganda during COVID-19. But before this, I would request that the panelists please put on your video feeds for everyone to see you. And Sigi, Victor, and Philip, you all have 1 minute to introduce yourselves to the audience before we go into the conversation about the report. So we'll start with Sigi and then follow that line.
Thank you, Jackie. Good morning, everybody, again. As I introduced myself earlier, my name is Sigi Mwanzia. I'm a digital program officer at Article 19 Eastern Africa. I may have forgotten to introduce Article 19 in the beginning, so I'll just give a brief introduction and say that we are a non-governmental organization protecting and promoting freedom of expression and access to information in 14 Eastern African countries, including Kenya and Uganda. And yes, I will hand over to the other panel.
Okay, Victor, next to you.
Good morning, everyone. My name is Victor Kapio. I'm a lawyer practicing in Kenya, and I was part of the research team from KICTANet. Thank you.
Philip, over to you.
Hi, everyone. Thank you so much for joining us. My name is Philip Ayazika, a programs manager with Pollicy Uganda. Just a little bit about Pollicy. We are a civic tech organization that functions at the intersection of data design and technology. We are based out here in Kampala, Uganda. And for us, being part of this project has been amazing because data is the core of the kind of work that we do, because we understand that data is critical when it comes to development of a country, planning, allocation of resources. So when a conversation about data protection comes up, and we know one of our cores is sort of holding leaders accountable and making sure they understand digital rights and making sure that digital rights are respected. So for us, it has been amazing being part of this project, and we can't wait to share the findings. Thank you so much.
Awesome, thank you. And I guess the virtual floor is open for you to share with us the report findings before we can open up the bigger session for everyone to join. So between you, Philip and Sigi, feel free to take us through the report findings.
Thank you, Jackie. I will kickstart us. Victor, maybe you can move to the next slide. So the way that we wanted to structure this presentation is we wanted to first start off by discussing the objectives of the report, as well as also providing a bit of background information. We then set out the human rights and the surveillance standards at both the international, the regional, and the national levels. We then look at the national frameworks underpinning surveillance, underpinning data protection, and also giving further effect to the right to freedom of expression in both Kenya and Uganda. Before we then dive into the meat of the conversation, which is, what were our findings, and then we cap off with recommendations. Victor, if you could move to the next slide, please. Thank you. So just for a bit of background and context, around September 2019, we received funding from CIPESA to do one of two things. One is to document and to review the surveillance measures and the practices of governments and of private sector private sector entities in both Kenya and Uganda, and to chart out the human rights implications of these measures and practices. We also set out to examine whether data protection frameworks were being adhered to by both government and private entities. So we restricted our examination and our review to the first year of the coronavirus pandemic. So that is March 2020, when announcements in both countries of the pandemic were officially released, up until March 2021. And we focused, as I've already mentioned earlier, on two countries, including Kenya and Uganda. Victor, if you could move to the next slide, please. Thank you. So the report extensively maps out the standards which apply, the human rights standards which apply in relation to surveillance. What we noted is that the collection of data and the mass and targeted surveillance practices are already provided for under numerous frameworks. So just as a starting point, we focused on three rights. That's the right to privacy and data protection, freedom of expression, and access to information. What is universally agreed upon is that these are mutually reinforcing rights, which continue to be impacted by mass and targeted surveillance, as well as by unsupervised data collection. And this issue of unsupervised data collection will be expounded upon later by Philip and Victor. We know that these rights are not just designed to empower the citizen, they are also very powerful bulwarks against state and corporate power. And they are also intended to improve the transparency and to improve the accountability of public and private bodies as they collect, as they use, as they disseminate our personal information across multiple systems and using tools of digital surveillance. The applicable frameworks which we canvass in the report include the Universal Declaration of Human Rights, which is given effect through the International Covenant on Civil and Political Rights, as well as the African Charter on Human and People's Rights, as well as national constitutions in both Kenya and Uganda. Victor, if you could move to the next slide, please. Victor, sorry, could you move to the next slide, please? Okay, as the slide is being worked on, what we had noted as some of the key takeaways in this particular section is that numerous human rights bodies have put out several red flags. And one of these red flags revolves around the issue of non-compliance of a number of coronavirus pandemic measures with human rights. What we have noted and what these human rights bodies flag out is that there has been an arbitrary and an unlawful use of surveillance measures and technologies, which has then led to the entrenchment of what is known as a surveillance infrastructure, which has permitted both state and private actors to continuously monitor individuals' movements in both countries with an impact beyond privacy and beyond data protection. The other red flag, the other takeaway that we noted Victor, if you could go to the preceding slide, just so everybody, that one before that, yes, that one, perfect. We also, one of our other takeaways in this particular standards section is that international law provides, as I mentioned during the introductory remarks, for the temporary increase of special powers during the coronavirus pandemic. However, the United Nations Special Rapporteur on Privacy noted that several minimum requirements must first be met before these measures, before these practices are deployed. One of the issues that is often emphasized and perhaps speaks to our over-reliance on legal frameworks is that legislative safeguards must first be provided. And in these frameworks, governments and private entities who are working in partnership with government must first prove to an independent and to a competent authority that the surveillance measure or the surveillance practice is legal, that it is necessary, that it is proportionate to the objective being pursued. Here, the objective would be public health. The UN Special Rapporteur also noted that the surveillance apparatus must be time-bound and that it must be deployed for a specific purpose. And we are all aware that the purpose limitation is expounded upon and contained in the data protection laws in both Kenya and Uganda. Now, one of the issues that the UN Special Rapporteur flagged out is that several countries have been repurposing their surveillance machinery, their surveillance apparatus, which was originally intended for state security purposes, to tackle the pandemic, which is a challenge. The third takeaway that we noted is that judicial oversight is required for targeted surveillance measures, which are deployed during the pandemic. And we also picked up in both public health laws that such powers have been granted and are granted to medical officers to control the coronavirus pandemic. The UN Special Rapporteur noted that in his report that there is a public health presumption which has led to greater such powers being granted to public health authorities, and that these such powers are actually greater than the such powers which are bestowed on, for example, police officers. Questions around warrants, questions around oversight, amongst others, necessarily pop up in this particular context. Thank you, Victor, for the next slide. The other takeaway that we noted is that communication surveillance and the right to remain anonymous are very central to the rights to both free expression and to privacy. And here I draw your attention to two foundational instruments, including the African Declaration, that is Principle 8, which categorically states that everybody has the right to communicate anonymously on the internet and to use appropriate technology to ensure secure, private, and anonymous communication. The necessary and the proportionate principles also clarify that states should refrain from compelling the identification of their users. The last takeaway that we noted under this standard section is that private sector entities have a responsibility, have a baseline responsibility to respect human rights. And this is contained in the UN Guiding Principles on Businesses and Human Rights. But we also noted that in both Kenya and Uganda that private sector entities also have obligations under the data protection laws that Victor and Philip will expound on in the next section. The UN Special Rapporteur for Freedom of Expression, Frank LaRue, who is no longer the current, but the former, Special Rapporteur, mentioned and noted that censorship measures should not be delegated to private entities, and he called for an immediate moratorium on the global sale and the tools of the private surveillance industry. And so I will hand over to Philip and to Victor to continue with the next sections. Thank you. Oh, yes, apologies. Actually, this was still my section. Philip and Victor, if you don't mind, I'll just quickly run through the national frameworks. So we looked at the constitutional protections protecting the three rights that I had mentioned earlier. That includes the right to privacy, the right to freedom of expression, and the right to access to information. And as set out in this presentation, we can see that all these are constitutionally guaranteed rights, and that states have obligations, have a responsibility, and obligations to promote important to protect these rights, including during the pandemic. Victor, next slide, please. Thank you. So what we noted, just in summary, in terms of the national law section, is that both Kenya and Uganda have a thriving legal surveillance environment, which had been enacted prior to the pandemic. In Kenya, we have several laws, including the Kenya Information and Communications Act. We also have the various security laws in both countries, which promote the use of surveillance and the deployment of surveillance measures in both countries. We also noted that, and this is one of the reasons why we selected and focused on Kenya and Uganda, is that both countries had already enacted their data protection laws prior to the official announcements of the pandemic. And so we believe that provided us with a baseline metric against which to assess the collection and the processing of personal data during the pandemic from both the private sector and the public sector perspective, but also just to see how rights, data protection rights, data protection principles were being respected and adhered to by both private and public sector entities. After the announcements of the pandemic, we noted and documented an expansion of public health laws in both Kenya and Uganda in the form of either rules or regulations. Yes. Victor, next slide, please. Super. So I will hand over to Victor and to Philip to break down the report findings. Thank you.
Thank you. Thank you very much, Sigi, for that introduction and elaborate of the various human rights standards that are actually applicable. We are going to present the findings in two ways. I will start with the various general trends that we observed in both countries, and then Philip will present on the various applications and the general concerns around how those applications were used. So with respect to the various trends that we've observed, 7 key trends stood out in the surveillance practices in both countries. The first key one that we wish to observe was the poor oversight of COVID-19 data collection. One of the things that emerged is that both countries have data protection authorities, but these authorities were not in place by the time the pandemic struck, and therefore they were unable to provide the oversight for at least a period of 9 to 12 months before they were constituted. So during that time, there was a lacuna in terms of oversight, and as a result, some of these abuses and violations occurred. Likewise, we're having a situation where the institutions that were empowered or that were carrying out this COVID-19 surveillance did not provide internal mechanisms to provide oversight over the activities that they were doing, but at the same time, there was nobody to supervise them. We also saw in Kenya, for example, the establishment of the publication of a guidance note by the data commissioner, but this one was only issued this year, coming almost a year after the pandemic struck and the data collection was done. The other major observation is that we still don't have independent data protection authorities in both countries. One of the things that stands out is that in both Kenya and Uganda, the authorities are established as state agencies and not as independent or autonomous bodies. Why is this important? In Kenya, for example, we have the Data Commissioner's Office under the Minister of ICT, and equally in Uganda, you have the Data Commissioner's Office falling under NITA, which NITA is also supervised by the Ministry of ICT. So as a result, this structural issue could affect the ability of the organizations, the data protection offices, to provide independent oversight and they cannot even supervise the institution that they're under, and that could be a challenge. The other challenge could be in terms of budgetary allocation, because they're going to be competing with other interests that already exist, or activities which are already been budgeted for. So they might not have the financial independence to effectively discharge their duties. Likewise, they might have challenges in terms of staffing, because the decisions to appoint are probably done by other organs. So in Kenya, you have the Public Service Commission, which is responsible for hiring. You have the Salaries and Remuneration Commission, which is responsible for the remuneration. So the Data Commissioner's Office doesn't have full control over those aspects. In Uganda, the leadership, the board and the executive director of NITA will have powers and decision-making capacity over staffing issues, and not the Data Commissioner's Office, and these are not provided in the regulations. So those are challenges that might affect the both the decisional and financial independence of these institutions to give effective oversight over the data collection that has happened during the COVID period. In other jurisdictions, such as in the EU, one of the things that is recommended is that there should be proper independence, and whether it is financial, having separate budgets to the data offices, so that they're able to plan and effectively discharge their duties. The other key trend that we noticed was that there was a lot of disclosure of personal data without consent. A number of the two public health laws in both countries, that is the Public Health Act in Kenya, give powers to public health officers to demand for information at ports of entry, for example. And travelers have to fill in these forms where they have to disclose the phone numbers, the names, the identity details, and whether they've even had symptoms of COVID-19. Likewise, the regulations that were adopted under the public health, those also require owners of establishments, or properties, employers, owners, or household heads to give information to the government about persons who are likely to be infected or have been infected with COVID-19 or are suspected to have COVID-19, disclose this information to government authorities, and this is not without any consent. We have a number of forms which are required to be filled. Kenya already has this Jitenge system, which is also being used to capture data. The same situation was also observed in Uganda. The guidelines on COVID-19 self-quarantine require individuals to provide information about their names, the next of kin, telephone contacts, and such other information. This is to allow government surveillance to continue. So we are seeing that despite having data protection laws, there are already existing laws that have created a system of information collection that is probably not regulated. The other trend that we noted was that the use of track and trace, or telecommunication data to track and trace individuals. This happened, we saw this in Kenya, where initially when the pandemic struck, location and data from telcos was used to track people who are being sent to quarantine, or to try to trace those who had left quarantine, to trace those who are coming into the countries. And the same have now been integrated in various applications, and there are very little or no protection to privacy or even regard for due process. We saw cases in Kenya where people who left the quarantine centers were tracked and traced using the telecommunication data, because initially they had to give the numbers. Likewise, in Uganda, just recently, the government and NITA, in collaboration with MTN Uganda, developed this e-pass application, which also relies on geolocation technology to track and trace movements of COVID-19 patients who are under the home-based care. And so once they leave the location, then their phone will send an alert to the ministry that this person has left the specific location, and these are problematic also. Within the EAC and the SADC COMESA region, we also identified the regional electronic cargo and driver tracking system, which is also a system of digital monitoring and surveillance of drivers' movements who transport cargo across and within the region we broke as they move across within the countries. Here also the drivers are required to provide information both for the drivers and the crew around things around their vehicles, their personal information. This is to aid surveillance of their movements. So we can see that use of telecommunication data is not just within the countries, but is also something that is happening across the bloc. And the challenge is that these ones are not properly regulated, and as a result, they can lead to a lot of challenges with regards to privacy of the individuals whose data is being captured. Likewise, at the EAC level, the Human Rights and People's Bill is yet to be adopted, and this legislation has provided a framework for the protection of privacy within the region. So that is also a gap that has emerged from this study. The other aspect that we captured was the use of CCTV surveillance and other with biometric technology or integrated biometric technologies. These include, for example, in Kenya, where you have around 2,000 CCTV cameras as of the last count. The government, together with Safaricom and Huawei, deployed this surveillance system, which captures, has facial recognition and movement recognition capacity. And the same was used to surveil and monitor public spaces and enforce social distancing within the major towns, such as Nairobi, and monitor the dawn to dusk curfew. Likewise, Uganda has a similar system, which is also able to check the motor vehicle license plates. And we saw during the last election how the same was used to track and trace people who are participating in protest, and therefore it is highly likely that the same has been used to monitor how the public were moving. The other challenge that we also observed was that medical officers and public health officers generally have, as Sigi had alluded to, very broad powers for entry and search. And traditionally, when we look at such powers, mostly with respect to security agencies, that most of these powers are not a blanket power, but there is oversight provided by the judiciary to give to issue the warrants or provide some form of oversight over how these warrants are actually enforced. For public health officers, there is no judicial oversight, and that we found to be a major gap. And as a result, public health or any officer who's delegated the power can enter, search and seize or move any individual who they suspect to be infected by any infectious disease, including COVID-19, to a government facility. And you see the absence of this oversight mechanism then is giving these officers a blank check. Lastly, what we observe generally is the lack of transparency by state and non-state actors. This generally relates to the agreements they have with these third parties of the nature of the applications that they're developing or the systems that they're developing. There's a lot of opaqueness with respect to these relationships, despite having an obligation to proactively disclose information. We find that there's a big gap in terms of just sharing information proactively to the public. Part of what we even saw in Uganda was that the privacy policy for the application do not provide comprehensive information about the the workings of the applications. In Kenya, what they had as a privacy policy was not a privacy policy. And so this lack of, proactivity in disclosure and, availing information then presents a big challenge to monitoring how governments actually are respecting the right to privacy. So I will stop there now and hand over to my colleague, Philip. Thank you.
Hi, everyone. Thank you so much, Victor, for that amazing sharing that you've done. To our participants, thank you so much for joining us. Again, my name is Philip Ayazika with Pollicy Uganda. I hope I'm very audible and clear. So I think for starters, I wanted to maybe just give an overview of some of the terms we are using here. They might be complicated for some people. We are talking about data protection, we're talking about surveillance. So data protection is basically a set of principles that organizations, governments, businesses have to adhere to in order to keep individuals' data safe and secure. And when you talk about data, we are talking about personal data, we're talking about phone numbers, location data, we're talking about people's emails and the other biodata. And when you talk about surveillance, it is simply inspection, I think, close inspection. I think the best example of surveillance that I can give is most of Kenya and Uganda, we have a very robust CCTV, those are the circuit camera CCTVs on the streets. I think that is the best example I can give for surveillance. So as I speak to the coronavirus apps and the issues that we found with them, I wanted to sort of put this out there that since the onset of the pandemic, there has been a lot of tech companies, governments, and international agencies that have since announced measures to help contain the spread of the coronavirus. And what stood out for us as we did this research and interacted with various both state and non-state actors, like you have seen some of the voices in the video, is that some of these measures imposed severe restrictions on people's freedoms, including their freedoms to privacy and other human rights. There were very unprecedented levels of surveillance, data exploitation, misinformation. All these things were being tested across the world. I think we've never had this level of, surveillance and data exploitation and misinformation. And many of these measures have been based on extraordinary powers. And whereas we acknowledge that initially they were supposed to work in just for temporarily, we are not really sure of how much or how long this surveillance is going to take. Whereas we agree that some of these measures that have been put in place may be effective based on the advice from the very many scientists. But we think others, some of them were not, whereas they were temporary, but some of them were not necessary and others were not proportionate. So I want to speak to the coronavirus app issues that we found. One of the things that stood out with the coronavirus apps that were developed in Kenya and Uganda was the gross impacts that they had on the rights to privacy, data protection, freedom of expression and access to information. Some of the issues that I'm going to speak about briefly are going to be the limited impact and effectiveness. We found out that most of these apps had very limited impact and effectiveness. The other thing is the non-compliance of applications with the privacy standards. The other thing is, the second last is the inadequate privacy policies that were put in place to ensure safety or data protection for the various individuals' data that was being collected. And lastly, it is about lack of transparency in partnerships. So speaking to the limited impact and effectiveness, ideally to ascertain the necessity of an app, it's important to do an impact assessment and check the effectiveness of these apps. And these are supposed to be measured. And to this end, most of these apps that were widely deployed were used by at least 60% of the population across Kenya and Uganda. And there's a lot of challenges when it comes to accessibility on the internet for Kenya and Uganda. For example, I'll give you an example with Uganda, where we have impediments of exorbitant prices being charged for the internet, and we have impediments like the OTT. So it's already tough to get to the internet. And then here we have a lot of applications, digital applications that are being rolled out. How are we ensuring that, or how are we sure that these are going to be effectively used by the various people that need to use them? So in Kenya and Uganda, we observed that broadband access and smartphone uptake is still growing, but this growth was not really reflected in the uptake of the coronavirus apps. For example, in Kenya, I think active mobile app subscriptions still stand at 59.8 million as of June 2020. And so the number of people that own mobile phones in Kenya still is, I think, 45% as of 2018. And here we are, for example, in Uganda also, we have mobile subscribers standing at 27.7 million as of December 2020, and smartphone ownership standing at 16%. So there's still so much work that has to be done in as much as connectivity is concerned. So I think one of the main issues that limited, the impact and effectiveness of these coronavirus apps was clearly the, broadband and connectivity and access to the internet. I also want to speak to the non-compliance of the applications with the privacy standards. So we did examine the compliance of the very many coronavirus tracing apps that are listed in this report. I think we had apps like the Linda app and the Jitenge app in Kenya, and then we had apps in Uganda like the Call the Clinic app. And there were very many apps that were developed even in Uganda with the Ministry of ICT initiative that put out a call to the public to sort of develop interventions, digital interventions. And I mean, we're really happy that the government is doing things and they're jumping onto the digital, the digital era and embracing all these digital interventions. But questions have to be asked. The interventions complying with the privacy standards that are in place? Are they taking in consideration data protection? Individuals' data, is it protected? Are there privacy standards being put in consideration? And for those that are going to navigate the report, you'll see there's a very detailed table that was showing all the apps that were developed and the various elements. I want to take an example of the Jitenge app. The Jitenge app, I think, like one of my fellows described it, I think Jitenge means self-isolation. The description of the app and what actually the app does are inconsistent. So there's inconsistency with the app, with the purpose of the app, and we also noted that the app in one way or the other breached the data minimization principle because there was a lot of data being collected. And I think this cuts across Uganda and Kenya. When you look at all the apps that were being rolled out, apps are asking for a lot of information, which contradicts with the data minimization principle. They're taking up, they have access to taking pictures and videos. They have access to location data. They have access to phone calls. They have access to preventing your phone from sleeping. So there's a lot. To also put context to this, in Uganda, we saw that out of the 20 permissions, just 9 out of the 20 permissions that were required to access and use the Ministry of Health CTC, that is, I think, called the Doctor app. Most of these permissions were unnecessary. And I mean, we have been talking about the 3-part test under the international law. These are things we need to take in considerations. Do these apps live up to the privacy standards that are stated under the international law? And no, this is something that stood out. The other thing was inadequate privacy policies. Again, we all have to acknowledge at least that privacy policies are important because they detail procedures and practices relating to the collection, processing, and storage of personal data. And for any of these apps to be rolled out, I think there must be a comprehensive privacy policy that must be put out to describe the app, describe the type of information being collected, to describe what are going to be the uses of the data being collected and what is the legal basis of all this data being collected. One of the things that stood out, for example, in Kenya, the Jitenge app the app does not have a privacy policy. For example, the document that was listed on Google Play, I think, and was indicated as a privacy policy was actually a guideline for program implementers and policymakers rather than their privacy policy. So we note that the failure of governments, specifically the government of Kenya, to develop and publish a specific policy for this app speaks a lot about the violation of the data protection and laws and principles. Same goes for Uganda. Another app, the app that was developed, which is called the Clinic, does not provide, whereas it provides a relevant privacy policy, but there's a lot of loopholes and gaps. It's clear that these were not clearly thought through, and there's very many gaps. So this is a call again to the various stakeholders, especially the government stakeholders. And I know Kenya has made progress in as much as passing the regulations of the Data Protection Act is concerned. But in Uganda, I think even on the onset, at least in the first year of the pandemic, we've not had regulations. And I think some of the loopholes we are seeing and the issues that are coming up are because there's no clear regulations and there's no clear framework on how some of these things are supposed to be done. Lastly, there was a lack of transparency in partnerships. So again, notably, we realized that most of the contact tracing apps that were developed by private actors. Of course, jointly deployed in partnership with both governments, entities. For example, in Uganda, NITA, the National Information Technology Authority, was key in partnerships and partnering with the public sector and very many entities. So while partners, we acknowledge that partnerships between government and the private sector are encouraged, and these relationships are very healthy in as much as having proactive and transparent governments is concerned. I think it's important that also put in consideration issues of transparency, disclosure of information. I think we need to push. We've always pushed for open governments and push for open data. We need to have access to the contracts. If there was any partnership, maybe between, for example, in Uganda, they call the Clinic app, which was developed between a private by a private entity and handed over to the Ministry of Health. We need to look at the contracts. We need to look at the data sharing agreements. What are the implications of these data sharing agreements? We need to look at procurement documents, budgetary allocations, among others. Kenya, again, the Ministry of Health partnerships remain in secrecy because critical documents that detail to the partnerships that happen between the Kenyan government and the private sector were not publicly available. Again, like I've said, even in Uganda, throughout this research, there's been a lot of information requests going out to NITA and other stakeholders. We appreciate some stakeholders have spoken to us, but the key information that we need to find hasn't been availed. So we call up governments to open up this information, make sure that the data is open and everyone has access to this data. Jackie, I don't know how much more time I have. I wanted to
actually, you don't have that much time.
Thank you so much.
So exactly. So I would like to open up the session for Q&A, and that will take us about 20 minutes. But before, and feel free to utilize the chat for questions, or you can raise your hand and you will be picked for any questions that you have. And the communications team in the chat as well, feel free to send me any questions that I would have missed. As we wait for the questions to come into the chat, maybe I just have one question to all of you, the panelists especially. The report recommendations are to government and private sector in terms of the people you're recommending to. But we all know that both the governments and private sector have no interest in data protection, because for the private sector, they're very much interested in how to monetize that data. And while the state, as we've seen in Uganda and Kenya, has extensively enhanced the data surveillance environment for the benefit of, again, for example, in the case of Uganda, for spying on the political opponents, and just intrusion that has been happening since early 2018, and the increase of data surveillance and biometric data specifically. So I'm curious to know, on the citizens' part, what is my takeaway from this particular report, or what would you recommend that I take away from this particular report? Anyone
Jackie,
wants to go first?
I'm not sure whether I should. We still had the recommendations walk through.
Awesome.
So maybe before Philip, Victor, and myself address those questions, I could just breeze through some of the recommendations in the report. Then we could address the questions.
Sure.
Sure. Thank you, Victor. Thank you, Jackie. And thank you to the audience, and thank you for your patience. I will be very brief. To governments, we had 5 recommendations, some of which are specific, others which are broad, intentionally broad. But just to cap off, in relation to the data protection authorities, we are calling for the introduction of measures which can guarantee the full independence of our data protection authorities, given the fact that a constitutional right is being overseen and is being given further effect to. And so we're calling for administrative, legislative, budgetary, and other practical measures to be put in place. Victor had already alluded of appropriate oversight and safeguards, including sanctioning the broad search powers which medical and public health officers possess, and subjecting these to judicial oversight. We are also categorically calling for a ban of biometric mass surveillance, be it untargeted or arbitrarily targeted surveillance in public and in publicly accessible spaces. And I'd love to hear some of the comments from individuals on this call on this specific recommendation. We are also calling for a review of all of the measures, all of the systems which have already been deployed during the pandemic, including data collection programs, including the data collection systems and any applications which are being used, and to ensure that these strictly comply with the 3-part test under international law, and to ensure that these also comply with data protection principles and data protection safeguards, including minimization, as well as privacy by design considerations. In terms of partnerships and transparency, we are calling for the proactive disclosure of all information, of all documents which are relevant to public-private partnerships, including, but not limited to, the disclosure of contracts, to data sharing agreements, to procurement documents, as well as to budgetary allocations. Victor, next slide, please. To private companies, we have 5 calls as well, also broad and some of which are specific. The first call, which we hear repeated time and time again, but which stands, is that private entities in both Kenya and Uganda, be they physically located or operating virtually, quote unquote, must respect human rights. They must comply with international human rights standards, and they must comply with national laws which promote and guarantee the rights to privacy, to data protection, to freedom of expression, and to access to information. We are also calling on companies to develop and to integrate comprehensive data protection measures and practices, which regulate their collection, processing, and storage of personal data. We are also calling for the integration specifically of data protection principles, including the purpose limitation, data minimization, data retention, and the prioritization of prior and informed consent across 3 stages. So that is the design, the development, and the deployment of all these technologies of products and services which are specifically tailored to tackle the coronavirus pandemic. To telecommunications companies and mobile network operators, we are calling for court orders to ensure that there is, before complying with government requests for individuals' data, and where any arbitrary, unlawful, or illegal data requests or orders are received from government officials, we are calling on private companies to refuse to comply and to challenge these orders in court. And lastly, we are calling on private companies, as we have had repeatedly, to publish transparency reports outlining outlining the issues which have been captured in this PowerPoint presentation. And so, Jackie, I will allow Philip and Victor to kickstart off the Q&A session with the question, by answering the question that you posed.
Awesome, thank you. Victor?
Thank you, Jackie. I think the question related to what can the public do. I think the first and important point is to know that the data is being collected and that there are gaps and challenges in terms of how that data is being managed, processed, and stored. And as the people have all the sovereign power, then they can, armed with this information, hold their leaders and these various government offices to account by asking questions and calling for greater transparency, calling for greater accountability over how the data is being used. They can still use the information to talk to the data protection agencies in the countries to start taking steps to ensure that the various measures are being enforced by the agencies that are collecting data. I think that as a first step is critical over and above just general awareness over what is happening in our countries and what we need to do about it.
Thank you, Victor. And Phil, if you have anything to say to add to that?
Right. Thank you so much, Victor. I just want to add to what Victor said about asking questions. I think as citizens, we should care. And I think one of the strongest powers that we have is to our voices as citizens. Of course, we don't sit on tables and, laws and all these things. So our voices is one of the most important things that we have. So it's important that we ask questions. It's important that we ask, how is our data being stored? Who is handling our data? How long is our data being stored? And where? All these are important questions. In Uganda, there's a tendency when you move into, a bank, I've even seen it at churches, there's a lot of data being collected in the guise of contact tracing, and following up on people that have accessed these institutions. And it's security personnel that are manning this data in books. I think Grace talked about, all these books and consent on who sees your data. So I think as citizens, before you give out your data, before you sign in that book, before you download that app, take a step to understand, get information about the app, read about the app, what kind of access, what kind of information or personal data that is apps accessing. And again, most importantly, ask questions about where your data is going and who is handling it, because you have a right to privacy. Thank you.
Awesome. So there's a question here from Sarah, and the question reads, does the report take into consideration civic education and the citizens' awareness on their right to data protection and privacy? Do people understand why their information needs to be safe and the implication of the use of their data by both government and private entities? Sigi, do you want to take this on, or anyone else?
Yes, maybe I can start off. Yes, to answer the question directly, the report does take these issues into consideration. I think one of the things that of the pandemic were put out, we all panicked, right? And where there's panic, there's always smoke, and where there's smoke, there is fire. And so during that whole process of panic, a lot of us ended up and I don't want to say ceding our power, but there was a process, a time period within which our own ability to, to come out clearly and say, or rather demand for rights protecting, for example, privacy policies amongst others was a bit weakened. What I want to also clarify is that the onus of civic education, the onus of citizen awareness, in addition to our own responsibilities, to learn about our own rights, just in terms of privacy, data protection, and freedom of expression, is that the offices of data protection in both Kenya and Uganda also have responsibilities under the two data protection laws to raise awareness about the right to data protection, about the right to privacy. And so, as we've heard from Philip and from Victor, there was a gap within which either these oversight bodies were not in place, and so this consequently led to reduced awareness, reduced education by citizens, given the fact that these bodies had not yet been constituted. So I think that those are my two preliminary responses. But yes, the report does take into consideration these issues. And its intention, in addition to reaching out to governments, in addition to the calls that are directed towards governments and private companies, is also to raise awareness amongst the general populace about what kind of surveillance measures, what kind of surveillance practices have actually been deployed during the first year of the pandemic, and how can we do better, just in terms of our own demands for accountability, our own demands for transparency, our own demands for our personal data to be collected and processed and used in a rights-respecting manner by these two actors in the surveillance environment.
Awesome. Philip, do you want to add in this, or Victor, do you have anything to add? No? Okay. Please keep the questions coming in. And there's a comment here from Keith, who says, kudos to the team that worked on this research, brilliant report capturing issues in open quotation marks, qua ground, close quotation marks. The recommendations are very well articulated and very specific. This, however, requires joint effort in advocacy and therefore awareness, that's in capital letters, and capacity is also in capital letters. Capacity building remains a point of synergy going forward. Thank you, Keith. I think that the panelists have taken in this kudos on the issues qua ground. So yeah, any more questions? Feel free to raise your hand. I see someone raising their hand. Victor, could you give them permission? I think that there are two
Jackie, I think
hands.
that is me, unless that is coming from the audience.
It's coming from the audience. I see two hands raised from the audience.
Hello.
Hello.
My name is Douglas. Yes, my name is Douglas Mawadri. I work in the civil society, and thank you so much for the webinar, but also more importantly, the recommendations and this undertaking time to come up with this very beautiful research on data protection and basically data. Particularly, my interests are drawn to the recommendations toward like civil societies, but also pretty much the human rights organizations. Because of the virtue of my kind of work and area of work, you may notice that there are so many kind of informations that are collected from beneficiaries of organizations, including human rights related issues that should not be publicly given out. But because that researchers and also individuals get interested to find out a few informations here and there, it could be for academic purposes, but also it could be for purposes other than just academic, just to ascertain data, but also to find out a little bit of information about a few things here and there. You find that people actually willingly give this information, but the usage of information at times gets out there, out of control, other than the people who control this information. I would like to hear from the panelists what recommendations they'll have for human rights organizations, but also maybe civil society organizations or individuals who collect information for academic purposes, but end up ending up into hands of individuals whom they may not have control over. So and also, what are the recommendations for in the event if some of these things get out of hand? Is it tenable to have litigation cases against some of these individuals and all organizations? Because at times there's consent, but at times this consent is also abused in the process. So that would be it from me.
Thank you, Douglas. I think that the question is, what would be the recommendations to human rights organizations and other people who are doing research when it comes to data privacy and data protection?
Thanks, Jackie. Maybe I can give some preliminary comments to the question, and then Victor and Philip can fill in. I think what we intended with these recommendations was not to canvass and capture. We do not profess that these recommendations are all-encompassing, and so what we envisaged with these recommendations is that there would be a rallying call. A rallying call to human rights organizations, to civil society organizations, to individuals, and also a reminder to governments and to private sector entities that, we are watching, we are observing, we are documenting, with the ultimate end goal of ensuring that these entities are respecting human rights within the surveillance ecosystem. And so to answer the question briefly, these recommendations, as I mentioned earlier, are a rallying call. So take them, repurpose them, reshape them to fit into specific contexts, to fit in, for example, as you mentioned, to academia. Repurpose them for purposes of your advocacy in the countries within which you are situated in, so that we can all collectively call out, as I mentioned earlier, for human rights to be protected. Thank you.
Thank you, Sigi. And I think we can take the next person. Rosemarie, I think, is permitted to speak.
Thank you, everyone. My name is Rosemarie Keller. I'm the director for the Africa Media Hub, and I've been actually instrumental in working in data both locally and globally within especially data for public good and within data and humanitarian, and was quite actually involved with the data protection bill when it was being enacted. My question is that we are looking at data back and look back around, especially digital rights. And digital rights here, I'm saying that for the longest time, everyone involved here, your digital rights has been captured by either ID bank, passport, and there are cases where people, when you arrive in America, even they know you even before you land, they don't even know your identity. So that humanitarian rights under the identity could be part of the things that you are looking when you're looking at the data protection, so that when you're looking at the GDPR, what kind of rights are we talking about apart from rights being captured just only during the pandemic? And then data for public good, I was involved in New York discussion about the data for public good. A lot of data actually is being hoarded by either telecommunication or private sector. Actually, private sector is ahead of the government. Here we are looking at the constitutional law, but we're not looking at the private sector and their role in actually holding of data rights. And data for public good, here comes a time where one of the person I've been working with, Stephen of New York University, saying that it's actually it's at a time that the telecommunication should actually be enacted to release data, especially during a disaster like the one we are having in the pandemic. And then this research should include how can we involve the telecommunication. Safaricom has got more data than any government institution here in the country. And one of the research that we were doing also in malaria, actually they had to reach out to Safaricom to give the data so that they could actually have a real data to analyze the impact of malaria in this country. So there's quite often no imagination of what the value of private data might be, especially when we don't look at the corporate telecommunication and private companies and they're holding to data. So what are you thinking going forward? How can we involve the private sector and the telecommunication? Indeed, the government has got those surveillance, has got those data rights, but how can the government work with the private sector to enhance totality when it comes to digital rights and data privacy? Thank you.
Thank you, Rosemarie, for that. And I think that maybe Victor, you just have like a minute to respond to that. We are running out of time. So if you could respond to that, then we can close the session. Someone in the comments had asked if the report will be sent to the participants' emails. I think that that's a brilliant idea. But also the report will be published on the 3 organizations' websites. So this report will be publicly available so that you can come through the details, and it's not that big of a report. It's like about 32 pages. So maybe Victor, you can just respond to that within a minute.
Thank you, Rosemarie. That was a very useful intervention and very interesting ideas about the data. I mean, data is the new oil or the new gold, or it's the most valuable product that we come to, in this era of information. And the challenge of data is when it is in the wrong hands or when it is used for purposes that were not intended. And the Safaricoms and Facebooks and Googles of this world collect data for business purposes, but some of that data is useful for other purposes. I think for me, the important thing is, are we clear about the objective for which we are collecting? Are we clear about the purpose for which we want to use the data for? So that even when there are public interest needs, then data protection is still embedded in those objectives, so that it doesn't matter who has the data, but there are sufficient safeguards and guarantees in terms of how that data is collected, what it is used for, and those purposes for which it is applied. Because at the end of the day, all this data, when put together, is beneficial for society. But in whose hands is it? In what way is it being used? I think those are the critical questions that we must all continue to ponder as we try to consolidate and extract uses out of data that is in different people's hands. It would make a lot of value for it to be to find ways in which the data that is already collected can be used. However, the organizations that already have data must review their methods, must review the data they have to ensure that whatever they have respect the rights of users. And if it has to be shared, then they are shared in line with the principles under the Data Protection Acts in both countries, so that then we can actually deliver those benefits that data has to provide, but in a very safe, secure environment where there are sufficient safeguards of that data.
Thank you, Victor. I would like to ask Grace and Mugambi to say one thing within a minute, and after that, that will bring a close to the session. Thank you, everyone, and the conversation still continues online because this is data privacy and data protection, so the conversation will predominantly live online. Grace, over to you.
Thank you so much, Jackie. I think we've had very interesting findings from the report, and we look forward to watching the videos because I think they have very interesting stuff. I just want to pick on one thing that Keith raised, mambo kwa ground. Ikoaji, the issue of awareness among data subjects. I think that's key, and we need a strategy on how to also engage ordinary citizens so that they question and they stop just giving their data, aimlessly. I just want to say as I close that the Data Commission's office through the policy advisor had actually wanted to join us today, but they have public participation engagements. And so she requested that once we finish this meeting, we avail the reports and the recordings to the office. And so hopefully that this is not the end. We will use the report to continue engaging with the Office of the Data Commissioner. And she is very, she's very positive and, looking forward to engage with people and looking forward to receiving more information. So thank you very much, everyone. And I really want to thank the team, Sigi, Philip, and Victor, because they have put in a lot of work into this. Asanteni.
Thank you. Mugambi, you have a minute because we're already over time.
Thank you. Let me put that on. But, my name is Mugambi Kiai. I work with Article 19. Just in closing, just a few remarks. So very quickly, is there any good news from here? I see none. And the warning is stark. If you actually read George Orwell's book, 1984, which actually he published in 1949, I think you see the consequences of this kind of mass surveillance, of unchecked power in the arms of a totalitarian state. So it's very clear. So what must we do? I think we know that the price of liberty is eternal vigilance. So the question for us is, what does a vigilance mean? It means that we must constantly watch. We must also get to know. And finally, we must act. We have got to act. Very, very finally, I want to thank the team as well. Philip, Victor, Sigi, well done. This is not good news. So in a sense, you brought us tidings, but thank you. We will not crucify the messengers. And last but not least, let me thank all those who attended this call for your patience and also for your good and robust participation. Thank you very much.
Thank you, Mugambi. And that brings us to the end of this conversation. Apologies for the 2 minutes eating into your time. Please feel free to go and check out the websites, all the website of the 3 organizations that will have this report. The videos will also be made available. Thank you to the panelists. Thank you to CIPESA and EDRF for making the project possible. And thanks for staying with us. Have a lovely day. Thank you so much. And that brings our meeting to a close.